Part 1 of the 5th schedule to the Senate Standing Orders on Tuesday, 15 December 2020, the Clerk of the Senate furnished each party with the documentations filed by each party. Honorable Senators, ladies and gentlemen, the hearing program, which has been circulated, details the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial that all the parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the clerks at the table. 15, in summary, the program states that today, Wednesday, 16th December 2020, after we have dispensed with preliminary matters, the charges against the governor submitted by the County Assembly shall be read to the governor. This will be followed by an opening statement to be made on behalf of the County Assembly. Thereafter, an opening statement shall be made on behalf of the governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence and should take us up to the end of today's sitting. At the sitting scheduled for tomorrow, Thursday, 17th, 2020, the governor will have an opportunity to present his case before the Senate. This will be followed by a closing statement on behalf of the County Assembly and a closing statement on behalf of the governor. 17, the Senate shall then proceed to a closed session for deliberations prior to voting on each of the charges in accordance with Section 337 of the County Government Act 2012 and Standing Order 75-6 of the Senate Standing Orders. The voting shall be by county delegations. The governor shall cease to hold office if a majority of the county delegation of the Senate vote to uphold any impeachment charge. If, however, the vote in the Senate fails to result in the removal of the governor pursuant to Standing Order 75-7, the Speaker of the Senate shall notify the Speaker of the Nairobi City County Assembly accordingly. Honorable Senators, ladies and gentlemen, this hearing is being conducted at a very challenging time when the COVID-19 pandemic is with us. As has been the practice in the sittings of the Senate since the start of the pandemic, the sittings shall be conducted in strict compliance with the COVID-19 guidelines issued by the Minister of Health and in various communications from the Chair. I therefore implore you, Honorable Senators, ladies and gentlemen, to observe and abide by the COVID-19 guidelines throughout the sittings. As I conclude, I would like to assure you all that the Senate is cognizant of the gravity of the matter with which it is seized and that it shall accord the parties a fair hearing. Honorable Senators, ladies and gentlemen, I now invite counsel for the Nairobi City Council Assembly to introduce the legal team of the County Assembly and the members of the Nairobi County Assembly representing the County Assembly by stating the full names and designation of each person. Yes, Senator Mtula Kilonzo Jr. Just a minute here.
Before we commence, Speaker, I'll begin with your last paragraph. Mr. Speaker, COVID-19 has not spared the Senate of the disease. And the way we are seated today is in violation of all the rules. Mr. Speaker, as we sit here, people are coughing, others are sneezing, your gallery is full. Mr. Speaker, how do we then give anybody assurance here that we have complied, yet people are sitting neck to neck on the other side? And your gallery, Mr. Speaker, you can see people are still walking in. This is the worst chamber to have a sitting with people seated in. We told you, Speaker, that we didn't want a plenary seated here where we would be so crowded. We don't want to sit in a death trap. And if we can't sit somewhere else, we should be told so that we go for virtual sitting, because this is a death trap, as it is. It is. And it's not worth it. It's not worth it at all. We have lost colleagues. We have somebody in the mortuary. This is a death trap, Speaker.
Okay, honorable senators, in the gallery, we were allowed the numbers that are sitting there, but inside here, we have to rearrange This cannot be allowed to continue because it's dangerous. I want to agree with Honorable Mutula Kilozo Jr. that as a Senate, we have also been affected by COVID. And therefore, whatever is before us is not bigger than COVID, it's not bigger than our health. So let us rearrange so that we sit according to how the seats have been designated. So let us do this. If you are sitting where it's not written, sit here. Please go to the other chamber. In any case, we are just going to do most of it's going to just to be hearing, going to be listening. So let's respect that rule. If you are sitting where it's not designated seat, please relocate. Yes, Senator, leader of my minority.
Asking members to relocate is also very difficult while you are sitting on the chair. Because while you are sitting on the chair and the mace is where it is, it means we are formally in session. Mr. Speaker, I would suggest we have a break of 5 minutes or 10 minutes, and people are allowed in strict compliance with the regulations. We cannot be seen, even the example we are sending out to the country is not proper.
Okay, order, senators. In that case, I want to suspend the sitting for 10 minutes.
Viewers, the Speaker of the Senate, Honorable Ken Lusaka, has directed that the sitting takes 10 minutes break. This is to allow for proper adherence of COVID-19 directive. We are taking 10 minutes break. We'll be back in a short while. Good morning. The 10 minutes break that had been ordered by the Speaker of the Senate to allow for proper sitting in the chamber in line with COVID-19 protocols just lapsed, and the bell you can hear on your TVs signals that the session ought to be beginning. The governor for Nairobi County will be defending himself against accusation leveled against him that necessitated his impeachment by members of Nairobi County Assembly. You remember that 88 members of the Nairobi County Assembly voted to send Governor Mike Sonko packing. Now the fate of that particular governor lies in the Senate, and it's upon him to prove to senators that that impeachment was done wrongly. In February, you remember this year, Sonko survived announced a motion after the court intervened, stopping the tabling of a motion against him. But that came to pass last month when members of Nairobi County Assembly impeached the governor. During the impeachment process, the governor was accused of gross violation of the Constitution, also matters to do with the misuse of public office and harassment of officers of Nairobi County Assembly. The members of County Assembly also said the governor was lacking the mental capability to run the county government of Nairobi. The motion moved by MCA Ogada. The session where the senator and the governor for Nairobi County, again the senators of the Republic of Kenya, where the governor for Nairobi County is set to present his evidence, set to be cross-examined by senators present in the chamber as well as outside, those sitting outside the chamber, to get to understand the grounds for removal of Nairobi Governor Mike Sonko. "59 members of county assemblies allied to Governor Mike Sonko, who happened to be with him in Kwale, however, claimed that their votes were illegally cast in the total votes, that is 88, who voted to have the governor sent packing. And today begins the first day when the governor for Nairobi County will be facing 67 senators after those particular special settings were gazetted by the Senate to allow for senators to hear and determine his impeachment motion. According to the Speaker, is that Sonko's case will be the only agenda before the House, after which senators will go for recess and resume on the 9th of February, the day the House is the normal sitting in the next year's calendar. As it is right now, the COVID-19 guidelines have been observed in the House, and the House is set to resume from the 10 minutes break. The Governor and his council introduced to the chamber before the hearing begins, and pursuant to Article 251 and 251B, the Speaker of the Senate just walked into the chamber
Okay, take your seats, honorable senators. Okay, I'll just read what I said last before we broke, that I'll now invite counsel for the Nairobi City County Assembly to introduce the legal team of the County Assembly and the members of the Nairobi City County Assembly representing the County Assembly by of each person.
May it please you, Honorable Speaker, members of the Senate. My name is Ndegwa Njiro.
And have your masks on all the time, all of you.
Thank you. I am the lead counsel in these proceedings. With me, I have Mr. Milimo, who is going to do of the team taking the proceedings. Much obliged. Mr. Milimo.
Mr. Speaker, sir, honorable members of the Senate, Milimo, I'm here to introduce the team from the Nairobi City County, starting with the members, one being Honorable Michael Ogada, the Minority Leader, Member County Assembly, Ward. The second, Paul Kigwadi, Majority Whip, Member County Assembly representing Miango Ward. The third one, Honorable Peter Imatok, aka Jateso, Minority Whip, representing the fourth, Honorable Moses Ogeto, Minority Deputy Whip, representing Kilimani Ward. I have with me my learned colleagues, starting with Michael Osundwa, Advocate of the High Court of Kenya, Mr. Duncan Okach, Advocate of the High Court of Kenya, Mr. Ndegwa Njiru, Mr. Ndegwa Mwangi, Advocate of the High Court of Kenya, Mr. Kevin Kokebe, Advocate of the High Court of Kenya, Mr. Biko Ashoya, Advocate of the High Court of Kenya, Mr. Gabriel Chesoro, Advocate of the High Court of Kenya, Ms. Cynthia Sheunda, Advocate, Mr. Ngira Dennis, Advocate of the High Court of Kenya. Mr. Speaker, that is the team from the Nairobi City County. I thank you.
Thank you very much. I now similarly invite counsel for the governor to introduce the legal team representing the governor and the governor by stating the full named designated person.
Thank you very much. Good morning, Mr. Speaker, sir, honorable members of the Senate, ladies and gentlemen. Dewey, I appear on behalf of His Excellency the Governor. I'm an advocate of the High Court of Kenya, Court of Appeal, Supreme Court, all subordinate courts in the Republic of Kenya. With me to represent His Excellency the Governor, I have Mr. Wilfred Nyamo. He is an advocate of I apologize. It's because of the muffling of my sound, my voice. I have also with me Mr. Kwanga Mboya, Advocate of the High Court of Kenya. Also with me present, Mr. Honorable Maanzo. He is a Member of Parliament. And I have with me also honorable members of the Nairobi City County Assembly, who, because of time, I will not enumerate each and every one of them, although they have been Excellency the Governor. in response. And I will, Mr. Speaker, sir, beg to save time by saying that we do have also over 57 of the said honorable members of the Nairobi City County Assembly, some of whom are seated in the Mr. Speaker, sir, allow me before I sit down that I invoke your rules in part 1 of the 5th schedule, which designate and delineate the procedure to be followed in plenary. We raised a notice of preliminary objection.
This
to the
was
proceedings.
order. You're
I
supposed to
Thank you.
introduce your members. We are yet to get there. So just
Thank you
do
very much,
what
Mr.
we have
Speaker.
directed you to do.
Very well.
On behalf of the Senate, I welcome the County Assembly's team, the Governor's team, members of the public and the media to the Senate and to these proceedings. I now invite the clerk to read the charges against Honorable Michael Mbuvi Sonko, the Governor of Nairobi City County. I thank you.
The Honorable Mike Mbuvi Sonko, the Governor, Nairobi City County. The charges against you are as follows. 1, gross violation of the Constitution or any other law. Gross violation of the Constitution, the County Governments Act 2012, the Public Procurement and Disposal Act 2015, and the Public Finance Management Act 2012. A, the Governor of the Nairobi City County has violated Articles 201A Constitution of Kenya on principles of public finance management and Section 154 of the Public Finance Management Act 2012, the County Allocation of Revenue Act 2015 on the use of conditional grants from the national government by the diversion or negated conditional funds, for instance, in the use of the road levy and bursary funds to pay for garbage collection contractors and lawyers, contrary to the bursary fund regulations and the approved budget. While the governor requested Kenya shillings 297 million from the controller of budget, these funds were illegally used to pay garbage contractors and lawyers. B, the governor of the Nairobi City County has violated Article 10, Article 201B and D of the Constitution by failing and or neglecting to comply with the provisions of Regulation 20 of the Public Finance Management County Government, which failure, refusal, and or negligence has compromised the provision of services envisioned under Part 2 of the 4th Schedule to the Constitution 2010, inter alia, most crucial provision during the raging pandemic. C, the governor of the Nairobi City County has violated Article 187(2)(a) of the Constitution and Article 5.2 of the Deed of Transfer by his continued willful refusal to warrants essential to the release of funds from the County Revenue Fund, which has grounded the provision of services of not only the county executive, but of the Nairobi Metropolitan Service and its exercise of the transferred functions. Violates the provisions of Article 187(2)(a) of the Constitution and Article 5.2 of the Deed of Transfer, whence the County Assembly duly adopted the budget of the financial year 2020-2021 and enacted the Nairobi City County Appropriations Bill 2020. The governor has violated the provisions of Article 183 of the Constitution as read together with Standing Order number 193 and Section 123 of the Public Finance Management Act 2012 by undermining the authority of the county assembly, whence the governor has refused to implement resolutions of the county assembly or forward a report detailing his inability to do so, in line with Article 183 of the Constitution, as read with Standing Order number 193, with respect to county public debt and debt management under the provisions of Section 123 of the 2012, failure of which the county has been unable to control and manage county public debt. The result is unmitigated accrual of debt, which has ballooned the county's overall debt to unmanageable levels, rising from Kenya shillings when he assumed office in 2017 to Kenya shillings 76.794 billion as at 31st December 2019, hence further violating the provisions of Article 201 of the Constitution. E, the governor has violated Article 227(1) on procurement of goods and services, as read together with provisions of the Public Procurement and Disposal Act 2015, by flouting the principles of public finance management in as far as public procurement of goods and services is concerned. Regulatory Authority, PPRA, faulted the procurement process for the construction of the Dandora Stadium. The authority flagged irregularities in the award of the tender, alteration of contract specifications, suspected irregular payments, and forgery of documents. The evaluators questioning the quality of work, the PPRA indicted the county government for paying Kenya shillings 196.87 million to the contractor. F, Section 35(4) and Section 45(1) of the County Governments Act 2012, as read together with Section 104 and Section 148 of the Public Finance Management Act, whence between 2018 and early 2019, and contrary to the law, Executive Committee Member for Finance and that of the Chief Officer for Finance were held by the same person, one Ms. Winfred Gathagu, which situation occasioned confusion and inefficiencies at the County Treasury, hence failing to promote good governance and compromising transparency and accountability within the county government. G, the governor has violated the provisions of Section 104 of the Public Finance Management Act on the responsibilities and powers of a county treasury, whence through inaction, action, omissions, and commissions, he continues the public finance management system, whence the county treasury remains ineffective. Despite various resolutions of the county assembly urging the governor to improve efficiencies by decentralizing the finance function to sectors as 148 of the Public Finance Management Act 2012, the county continues to operate in contravention of the law. H, the governor has violated the provisions of Article 5.5 of the Deed of Transfer of Functions by his refusal to hand over the necessary documentation to enable the Kenya Revenue Authority optimal revenue collection under the transferred functions. For instance, by the end of June 2020, the county had collected just Kenya shillings 8.4 billion against a projected revenue target of 17.05 billion, partly due to failure by the county government to facilitate the Kenya Revenue Authority to hit its optimal potential as the revenue collection agent appointed pursuant to the Deed of Transfer of Functions. I, the governor, grossly violated Article 201 of the Constitution, use of financial resources, and Section 159 of the Public Finance Management Act 2012, as read with Section 7 of the Nairobi City County Tax Waivers Administration Act 2013, by unilaterally and arbitrarily in total disregard of the law. The governor was aware that the law provides that waivers should be granted by the CECM for finance. J, the governor has violated the provisions of Article 201D of the Constitution on principles of public finance in the Republic and Article 227(1) on procurement of public goods and services and the provisions of the Public Procurement and Disposal Act 2015 by willfully interfering in the award of the tender for the construction of the Dandora Stadium as established by the leading to loss of public funds in overseeing payments despite concerns by technical officers. K, the governor has violated the provisions of Article 201 of the Constitution and the Public Finance Management Act 2012 on principles that guide all aspects of prudent use of public finance or negligently. He presided over massive loss and theft of county public funds in the 3 years he has been in office, as evidenced by the Auditor General's report of 2018-2019, which raised the red flag over the city's stalled 204.2 as well as failure by the county government to meet its revenue targets. L, the governor has violated the provisions of Article 5 of the Deed of Transfer of Functions by sabotaging the transfer of functions. The governor is yet to provide NMS with crucial information necessary in aid of the transferred functions. For instance, failure to facilitate NMS with data on ongoing projects, pending bills, and staff payroll details on transferred functions has greatly derailed the performance of these functions to the detriment of the public good. Charge number 2, abuse. A, the governor has abused his office by violating Article 75 of the Constitution, as read with Section 11 and 13 of the Leadership and Integrity Act 2012 on the conduct of state officers, where the governor has persistently intimidated, harassed, and molested, including blackmailing his county executive committee members and chief officers with 1-year contracts whose renewal, leaving the officers jittery about their employment and creating a climate of fear, uncertainty, and despondence. For instance, in May 2019, the governor failed to renew the contracts of all 23 chief officers, instead directing that they hand over to directors, greatly affecting the continuity of service delivery and accountability in the county. B, the governor has abused his office by violating Article 75 of the Constitution, as read with Section 16 of the Leadership and Integrity Act 2012, by unlawfully using public funds to pay for his daughter's travel to New York, USA, to allegedly attend the county First Ladies Conference held during the 62nd session of the Commission on the Status of Women 2018. Third charge, gross misconduct. A, that the governor has violated Article 73 of the Constitution by failing to promote public confidence in the integrity in the office of the governor, following his being charged before the Anti-Corruption Court, and or compromising the social contract and trust bestowed upon him by the people of Nairobi by virtue of Article 1 of the Constitution. As a consequence, therefore, the governor has been barred from accessing his office via a court order and thus incapable of performing his functions of the County Governments Act 2012. B, the governor has violated Article 73 of the Constitution and Section 8 and 11 of the Leadership and Integrity Act 2012 on public trust and professionalism, where he is on record admitting that he was intoxicated and thus not in the right frame of mind when for the transfer of certain functions of the county to the national government in February 2020. In his own words, hawa watu wa State House walini confuse na pombe kwanza. By the time I was meeting the president for the signing, I was just seeing zigzag. This allegation of impropriety on the part of State House imputes improper motive on the office of the president and brings disrepute, ridicule, hatred, and contempt to the office of the president and of the governor. C, Article 73 of the Constitution and the Leadership and Integrity Act 2012 on the responsibilities of leadership by failing to professionally perform his constitutionally sanctioned duties owing to his constant absence from office, even before he was formally restrained by the courts from accessing his office, whence the governor remained constantly unreachable in person or on his phone for inordinately longer periods of time, to the huge detriment of the performance of the functions of the county executive. Indeed, the governor to execute the functions of the county government from his home in Moore Hills, Machakos County. D, the governor has violated Article 75(1)(c) of the Constitution as read with Section 11 of the Leadership and Integrity Act 2012.
Members of the Senate, you have the mandate to exercise your authority within the as read with the relevant standing orders of the County Assembly. Honorable members, if any of you were to ask the advocates or any of the witnesses of the County Assembly, did you furnish the governor with the evidence you are tabling before us? Honorable members, the answer will be fumbling. But if you ask them, isn't it so that Standing Order number 72, sub 2, says that you should provide the governor with the evidence at least 3 days before the debate on the motion? Honorable members, you will find no evidence. You will find nothing that demonstrates, not even in the Hansard from the County Assembly, that that mandatory requirement was met. Honorable members, Mr. Speaker, sir, in the result, the bundle that is before you stands expressly barred, which is the position of His Excellency the Governor, by operation of Rule 19 of Part 1 of the 5th Schedule to your standing orders. That is a sieve, the standard against which you, honorable members, will inquire. Has the threshold for the evidence now, County Assembly, you're presenting to us been met? Did you present? Why I say so? Why His Excellency says so, and will insist in furtherance of his objection on a preliminary way, honorable members, is that your own expression by way of the impeachment bill 2018, you had expressed yourselves on the floor and therein stated in section 15(1) of the Impeachment Act that a certificate must be produced before you, Mr. Speaker, by the Speaker of the County Assembly, that there was compliance with that. His Excellency the Governor has sworn a deposition saying I was never presented with any evidence. You will ask, therefore, pursuant to your Rule 19 of Part 1 of the 5th Schedule, is that evidence admissible? Is that evidence that you can look into? It is barred by express operation of your rules. Honorable members, this is an honorable house that is governed and regulated by its rules. And honorable members, I am so happy that, Mr. Speaker, sir, you have issued rulings and directions, Solomonic, to direct, and His Excellency the Governor is humbly requesting that, honorable members, we abide by the rules, of your standing orders, wherein His Excellency is saying the accusations leveled against him were contained in nothing but what, Mr. Speaker, sir, you have in the opening of this session enumerated and said that on the 4th of December 2020, a communication came from the Speaker of the Nairobi City County Assembly. And what did it contain? A, the motion that has the charges. B, the list of the members who allegedly subscribed to that motion. And C, the Hansard that was there. Honorable members, the question is now, that communication did not contain a list of the witnesses that are now sought to be introduced, barred by your Rule 19. You cannot, therefore, look at those documents containing the evidence. You've been told by the counsel for the county assembly. They will call evidence to demonstrate. They will call evidence to demonstrate. Honorable members, I'm afraid, with tremendous respect, Mr. Speaker, sir, Rule 19 of Part 1 of the 5th schedule of your rules expressly forbids, which is the gist and the thrust of our preliminary objection. And you have heard it be told to you that His Excellency, the Governor, failed, refused, objected to assent to the Nairobi City County Appropriation Act of 2020. But they've omitted to inform me in their opening statement that that is a matter pending before court. The Constitutional Court yesterday, as late as yesterday, declared itself before the Honorable Justice Burima, Constitutional Petition E348 of 2020, which again has another hearing date on the 18th of December. Honorable members, His Excellency the Governor is saying your standing orders in Standing Order number 98 3C forbids you from venturing there. And may I remind you, honorable members, you have deference for our court. The judicial authority espoused in Article 159(1) of our Constitution derives from the people. But the county assembly wants you, honorable members, Mr. Speaker, sir, to trample on that right, on that authority. Mr. Speaker, sir, His Excellency the Governor, by means of his preliminary objection, has stated that his refusal to assent to that Appropriation Act is sub judice. And he will demonstrate in his preliminary objection, which Mr. Speaker, sir, will urge and request. Speaker, sir, this honorable House, in deference to the judicial authority that is espoused in Article 159(2), is this honorable House defers that. And yet, cognizant of this very fundamental aspect, Mr. Speaker, sir, honorable members, which His Excellency the Governor will demonstrate to you in their own that yellow volume. That should be volume 1. Are annexed the orders of the court showing that the proceeding is alive. And therefore, my honorable, lovely members of the Senate, His Excellency the Governor is saying there are pending proceedings implicated herein is it feasible for you, honorable members, Mr. Speaker, sir, to suspend and close your eyes and act blind, with tremendous respect, to the provisions of Standing Order number 98-3C? His Excellency the Governor will beg the floor on a preliminary nature. By virtue of Rule 13, he will move this honorable House, Mr. Speaker, sir, to request and urge you to make a ruling on Rule 13. And Rule 13 of your standing rules in Part 1 of the fixed schedule permits you to grant half an hour for the adjudication of the preliminary objection. Honorable members, the issue will be now, if you are not satisfied, if you see no statement from the Speaker of the County Assembly that there was indeed compliance with the preliminaries of the purported impeachment, unfortunately, with tremendous respect, honorable members, you have to down your tools. And this is expressed in Section 15 of the Impeachment Bill 2018. It has passed from you, although it is pending before the National Assembly, for persuasion. And then His Excellency will demonstrate and he will show your honorable members, Mr. Speaker, sir, that an issue that is pending before the court that is alive freezes whatever actions that are therein contained. And the pending impeachment motion that was originally filed on the 20th of February 2020 by the named third witness, Honorable Peter Imwatok, His Excellency the Governor will demonstrate, has never been withdrawn by operation of the standing orders of the Nairobi City County Assembly. Therefore, His Excellency the Governor is saying he has been subjected to an unfair process. That which violates Article 47(1) of our Constitution can never be validated retrospectively, introspectively, or otherwise howsoever. It cannot. It is dead on arrival. Honorable members of this House, let me rehash that on the 24th of September this year, that the High Court intervened in a very crucial aspect of the existence of this House and the life of your tenure. When this honorable House, as well as the National Assembly, were threatened with, should I say, the truncation of its current term, the High Court intervened in deference to that decision, honorable members. We are gathered here before you, and honorable members, in 2013 as well. Mr. Speaker, sir, you did ask the Supreme Court to assert the authority of this House by judicial intervention, and it was indeed declared that this honorable House has that authority that cannot be whittled down, it cannot be otherwise compromised by any writ or any action or even judicial ingenuity. Honorable members, His Excellency the Governor therefore implores and urges you that as we delve into, you give him the opportunity in furtherance of Rule 13 to demonstrate to you that the issues of his alleged commission of national crimes purported in the accusation number 1I, that he is not able to address the same matter sub judice. The issue of the alleged non-funding of NMS, His Excellency the Governor is not able to address on you. He defers to your standing order number 98-3C because the High Court in petition E348 of 2020 Nairobi City County Government versus NMS, His Excellency. Sorry, Mr. Speaker, sir. His Lordship, Mr. Honorable Justice Mrima, has stayed the operations of that act, under which, honorable members, the NMS has been claiming funds. How is it then His Excellency can be accused of failing to release funds to the NMS? In all fairness, honorable members, you will see, therefore, that those charges, 90% of which relate to court proceedings, cannot be incised, removed from, or otherwise extricated from the last paragraph 4 allegations. Honorable members, inevitably, in the end, we have to assess the application of the Rule 19 of this Honorable House standing orders to the 5th schedule, part 1. Honorable members, so that I yield the last 15 to Mr. Nyamu, my learned friend. I will yield to him so that he can demonstrate to you that what is masked in the position of His Excellency the Governor, what is masked as an impeachment process, it is a witch hunt. For what? Because His Excellency the Governor has insisted being a stickler to the law, just as he is before you. They received the preliminary objection. They know they never filed any evidence. Mr. Speaker, sir, honorable members, they filed nothing before the assembly because nothing was tendered before you on the 4th of December. Honorable members, you would have scrutinized that by now. You would have known by now. You would have seen and answered by now. You would even have, in minuscule way, your honorable members, Mr. Speaker, sir, seen the veracity of the said alleged evidence. Mr. Speaker, sir, there is one very fundamental aspect. If a man should be denied audience, if a man or a woman should be denied audience when they are faced with accusations and then sentence is passed against them, is that not in violation of your standing order number 75? That every person should be given a hearing, even the county assembly own standing orders. His Excellency the Governor wants to show you in standing order number 72, 1A, there was no compliance. And if a man or a woman should be told, I'm charging you with this, but with no evidence, no court of law would convict them. Mr. Speaker, sir, I therefore urge you to allow us, as His Excellency the Governor is beseeching you, honorable members, that if a matter pending before court, even the county assembly lawyers will be aware to confirm, it is before the Honorable Justice Ndomanderi today at 3 p.m. for a ruling. It's a live proceeding. Does it meet the threshold of standing order number 98? 3C? It does. It does. What do we do in the circumstances? We have to yield and yield, Mr. Speaker, sir, honorable members, to the standing orders. They advise us. They map the way forward. They are the beacon light telling